Good afternoon. I'm Erin here with the 345 News. I'm outside of the Supreme Court where the Supreme Court is about to convene to make a major decision on the Sullivan v. New York case. This court case is of extreme importance because the Supreme Court is making a decision on the First Amendment and, more importantly, the freedom of press. I'm here with Sullivan to talk about this side of the case and how he thinks they will rule today. So Sullivan, what is your stance on this case? Why did you file a suit in the first place?
The New York Times are obviously trying to ruin my reputation in their article. They say they were mistreated by the police. Well, I'm the head of the police. Who else are they trying to jab at other than me? I don't understand what allows these blacks to even talk about me, much less try to defame me, and they should be dealt with because of their libelous statements.
What will you receive if you win this case?
I'll get my satisfaction and my $500,000 in compensation for my defame. Those colored people will get what they deserve.
Are you confident in your case?
Of course. Who would take their side? Alabama already proved it, and they are certainly smart and prestigious people. Plus, there were minor errors in the article that weren't true, which obviously solidified my case.
Alright, well thank you, Mr. Sullivan. Now time to tune in for the New York Times side. I'm here with the New York Times representative to clarify the New York Times side of the current court case. Would you please explain your side of the argument?
Well, on March 29th, we carried a full-page advertisement trying to solicit funds for Martin Luther King Jr. against his perjury indictment in Alabama. This advertisement went into detail against actions against the civil rights protesters, which involved the Montgomery, Alabama police.
Were these details accurate?
I will admit some were a bit inaccurate. Our one writer wrote that King had been arrested 7 times when at the time he'd only been arrested 4.
Oh, interesting. I understand that Sullivan, the Montgomery Police Safety Commissioner, asked you to retract your statements.
He did, and we didn't. Instead, we wrote a letter saying that we were confused at how he thought that the statements reflect him in any way, and that if he wants to, he should let us know that in what respect he claims that our statements in the advertisement reflect on him.
But you published a retraction of your statement when Governor John Patterson of Alabama asserted that you do so?
Yes, because we didn't want anything that we published by the Times to reflect the state of Alabama, and as far as we're concerned, the governor was the embodiment of the state of Alabama. Also, we had learned by this time that more factual information which the ad recited, and the ad did refer to the action of state authorities and the Board of Education, which the governor is the ex officio chairman, so we felt that a retraction was in order. However, we still failed to see how any of the language in the ad was referred to as
Alright, thank you for meeting with me, and we'll be back soon with the verdict. Breaking news! The court's verdict has been made. A unanimous vote has decided in the favor of the New York Times, declaring that they do have the freedom to run that ad in the paper. The Supreme Court had overturned the lower level courts of Alabama, and the Supreme Court is exercising judicial restraint in interpreting the Constitution directly as it was written in the First Amendment. The law of the land has been revolutionized, and people and the press are now free to speak up and out about racial injustice and other public. I'm Erin with the 345 News. Thank you, and good afternoon.